Hey, welcome, welcome. So far, I'm welcoming myself. I don't see anybody yet, but hopefully somebody will be here. Welcome tonight, live on YouTube. And we're just going to do this on YouTube and not on Facebook tonight because I can't see everybody's name and stuff on when I go through StreamYard, and I want to be able to see you guys in here and to make sure I got a roll of who's checking in and who ain't here. So welcome, Advocates for Justice, Foreclosure Defense, Paralegal Service. We are different and we prove it. And wait. Let me give myself a thumbs up because I'm very sure I'm going to like. Oh, somebody else gave me a thumbs up too. I got 2 thumbs up. Somebody else is sure that I'm going to kick butt tonight with tonight's subject. Okay, sorry. I'm already getting sidetracked. So tonight we're going to talk about what we've been talking about. Apparently, if you're in this fight and you need to start someplace, where you need to start is the jurisdiction playlist. I have, all of the documents, all of the videos on my YouTube channel are sectioned in the playlist. So the jurisdictional playlist is a great place to start because the jurisdiction challenge is the only thing that we go by. That's the only thing we use. We don't use none of that other stuff. We stick with the jurisdiction challenge, and I'll tell you why. The reason I stick with the jurisdiction challenge and I don't go over none of that other stuff because all the stuff they're saying is fraud, okay? So if you go to court defending yourself against their fraud, at the end of the day, you're still going to be standing in a big pile of fraud because that's all there is fraud. You got fraud at the beginning, fraud at the end, and fraud. Okay, okay, you got the point, right? So it's not going to do you any good to go into court defending yourself against their fraud because you still are in the fraud. So what we need to be doing is holding them accountable for fraud. Okay, I won't go into all of the fraud on this, but we need to hold them accountable for the fraud that you're facing right now. That, to me, that's a whole lot better deal to go in a higher court holding the person that signed to start the foreclosure against your property, holding that person liable in a higher court, and make that person have to get an attorney, and make that person have to spend some money, and make that person look stupid in court. Yeah, you notice how I added that in. If you watch the video that I made yesterday, or the live stream I made yesterday, yeah, we talk about how they like to make you feel stupid in court to steal your hope. But we ain't gonna have no hope stealing up in my program because they're gonna be worried about their own hope by the time you get done with them. So today today we're making the jurisdictional video, the instructional video for the jurisdictional challenge. That's what we're making today. And it's going to be short. And, after using the documents that you guys have, the lawsuit packages and documents you have, it should be real simple using this jurisdiction challenge. When you look at the documents in it, you should already know what you need to be doing with them. But some people, this is new to them. Some people let their fear run their anxiety up high enough, and when your anxiety is up too high, your brain's not working well. Okay, your brain don't work well when you have high anxiety. That's why you have to breathe into the paper bag. That's what I tell people sometimes. They need to breathe into that paper bag. If you can't control the fear, you have to do it scared. Okay, someone posted that on their page, and I asked if I could borrow it because I love that. If you can't control the fear, you have to do it scared. That's plain and simple. So today we're going to review the instructional video for the jurisdictional challenge with an affidavit. Last night we talked about the things that you need to make sure are not going on in your jurisdictional challenge with an affidavit, like number one, the judge answering for the attorneys, or the judge telling you the attorneys they don't have to answer and you not to worry about it. Because if they don't answer in the time frame they're supposed to answer, they need to be defaulted ASAP. We don't give a crap what the judge say. Okay, we ain't listening to the judge. We talked about that last night too. We ain't waiting around for the judge because we already know who the judge is helping, and we already know the position the judge is going to be in when we get done setting them up. So, and that's what we finna talk about right now. So let's just get. Before we get started, I want you guys to make sure you subscribe if you haven't subscribed yet, and click the bell so you get notifications when it's time to rock and roll. And please leave comments. Leave comments on the page underneath the thing there in the comment section. I'm going to leave a link to both of the lawsuit packages that we're going to talk about today, the jurisdictional challenge with an affidavit, and I'm going to touch on the claim against the judge for violating the jurisdictional challenge with an affidavit. But the instructional video for that one will be in a couple of days. So I don't want to run the two together because then people will be getting confused. And then I have people telling me that I need to make things more clear. I had some lady in the private Facebook group telling me I need to make things more clear. And I don't think she realizes that these documents that I'm structuring come, like someone will call me from New York, hey, this is what they tried. Oh, hell no, we need to shut that down. So we add something to it, or we change the document. Or in the jurisdictional challenge with an affidavit, what we did was we put a notice on there. And the notice blocks, theoretically, okay, blocks the judge from actually dismissing it or having it as a, yeah. But someone from New Jersey or from somewhere looked up in their rules, and their rules stated that if it's a notice, they don't have to respond to it. I was like, well, that's fine. If they don't respond to it in the 21 days or whatever they have to answer, I'm still going to default them. I don't care about their rules. So at the end of the day, you're going to default them, and they're going to say, well, we didn't respond to that because it was a notice. Are you kidding me right now? That's not the way it rolls, especially if you got fire on the table. Okay, then that's not the way it rolls. So I told that person, I tried to explain to that person, the goal is to stay in your house as long as you can. So if you can back them in the corner to where if they don't answer, you get to stay in your house, then sounds like a good plan to me. But her goal was to go before the judge so the judge can grant you the default. that ain't never going to happen. That's not going to happen. The judge, I haven't seen the judge grant anybody a default. What you have to do is you have to turn the heat up on the hot potato so nobody wants to touch it. That's what you have to do. And if you're looking to have the documents match all of the rules and match all of what attorneys think you should be doing, you're in the wrong program. Okay, you're in the wrong program. And if you're looking for it to be easy, you're in the wrong program too. Okay, because the goal is to learn how to do this yourself. Okay, and you're not going to learn that making it easy. Now, I don't go around trying to make it difficult because I want it not to be easy. But here's the deal. I'm a one-man show doing all this stuff. I got the documents, I'm putting the websites, I have like 5 Facebook pages, I have my Google AdWords account that I'm trying to run, then I have the YouTube that's up in the, yeah. So I don't have time to, this person said if I have more than one jurisdiction document, I can have one be L1 and L2 and L, that's a pain in the ass. I don't have time for all that crap, okay? You can do the L1 and the L2. I go by the title of the document. That's the only way I can remember what it is. When you tell me, hey, I got jurisdiction document L1, that's not gonna ring nothing in my head. If you tell me I got the jurisdictional challenge with an affidavit, oh, okay, I know. Oh, or if you tell me you got the jurisdictional challenge for the eviction court process, oh, okay, I know exactly what we're talking about. But L1, L2, L3, no. Anyway, I just want to throw that out there. If anybody, and I actually deleted that person from the group because that person was just arguing to be a pain in the neck. Okay, people need to step back and take a look at. I mean, you're lucky to have an opportunity to go and stick some fire in somebody's face. I would not want to be getting in the coach's face complaining about you're having to work too hard or it needs to be easier or all of that. And the sad thing is, the person that started all of this, okay, received her documents back in April, and she's just now getting around to getting them done. And yeah, so the problem, it appears to me, is that someone sat on their butt and didn't do what they needed to do, and now they're backed against a wall and they're complaining because it's too difficult. Well, I hope you get it together so you can save your property, because that's what's important. Now, the judge is not the party that is supposed to respond to the jurisdictional challenge with an affidavit, or the jurisdiction, or a jurisdiction challenge. So this is what people are missing. They're thinking like attorneys, like they have an attorney working for them, or you're on the same program as an attorney, and you just file your stuff and you wait for the judge to rule on it. No. When you file your stuff, they're supposed to respond, and you get to reply before the judge gets involved. So if the judge gets involved before you get a chance to reply, then it's a problem. But when you file my jurisdictional challenge with an affidavit, I've already mentioned several times, they're not going to be able to respond by counter affidavit. They're not going to be able to respond properly. And you have a motion in there to moot all of their pleadings until they do respond and prove on the record. You don't need to be waiting for the judge, okay? If you're waiting for the judge, you didn't read the instructions, you didn't watch the video, and you're in trouble, okay? Because the judge is not going to help you. So you need to go to the Federal Rules of Civil Procedure. You need to check and make sure the time frame they have to respond, and when that time frame is up. And when that time frame is up, I'm already telling you they're not going to be able to respond, so there's no reason you shouldn't have your default document ready to stick right up in their face. That's how we do it. So the jurisdictional challenge with an affidavit package has 6 documents in it. 6 documents in it that you're getting on sale now for $200. And that's I don't know, I guess what kind of, it's not a fire sale. I guess we're going to call it I hate attorney sale. Yeah, I like that. That's what we're going to call it. The I hate attorney sale. $200. Now, this jurisdictional challenge with an affidavit would be perfect to use if you're in judicial foreclosure. It would be perfect to use if you're in a non-judicial foreclosure and you are at the eviction process, because this will jam up the eviction court, jam up the whole thing. And the information in this jurisdictional challenge would be perfect to be put in your wrongful foreclosure / breach of contract lawsuit. Yeah, and I'll tell you this, if you understand the information, if you understand the facts in the jurisdictional challenge with an affidavit and understand how to apply them, you will be able to make them get out of your face. And you do that by the phone conversations, by the Zoom conversations, by talking to the clerk on the phone or whatever. Whenever you're dealing with these people trying to steal your stuff, you need to understand that they're sizing you up. Everything you say, they're sizing up to decide if you have any idea what the hell you're talking about. And if you don't, well, you people know what happened if you don't. If you don't have any idea what the hell you're talking about, and you let them know, they're going to send you on a wild goose chase, and they're going to start telling you you need to do all this other shit to your documents and all this other stuff just to keep your ass running around, to steal your hope. That's what they are. They're hope stealers, and we're going to put an end to that. Hope stealers and the fraudsters. Okay, never mind. I'm getting carried away. So the jurisdictional challenge with an affidavit, the first document is a jurisdictional challenge with an affidavit. And it's actually has a different name in the file, but you'll be able to see it. And I'm going to just go over the name of these, and then I'm going to open them up, and we'll take a look at the first page of them so you can kind of get an idea of what we got. Well, before we do that, I'm going to double check and see who's all here. Hey, James Galley and Ollie's here. Got 6 people, so I got some people watching incognito. Hey, you guys say howdy so I can know who's here. I'm taking roll. Whoever's not here by now is going to have to run some laps. They'll be really short laps. They'll be around the kitchen. How's that? Okay, you can run to the kitchen and get me a glass of wine. Okay, never mind. Sorry. Dylan Shea, hey. Okay, somebody asked me a question already. Wise owl. And wise owl is being too wise. So we're not going to worry about wise owl right now. So let's just get back to work here. So the jurisdictional challenge. So the second motion in the package is a motion to moot all the pleadings until the attorneys prove jurisdiction on the record. So that's probably the second motion that you would file. And keep in mind, the way I have these set up here may not be the way you have to use them depending on your situation. In most cases, the first 1 and 2 would probably be in order. But as long as you understand what the motion is and the goal of it, then you'll know when you need to use it. And this is what I try to tell people. You need to understand the goal of the motion, what it does, and why you're using it. And then you know when you need to use it. Okay. So the motion to moot all the pleadings that the attorneys filed until they prove jurisdiction on the record, that's powerful. And the first time we used that, the attorneys asked for a continuance. Well, they couldn't respond by counter affidavit. So there was that. And then they asked for a continuance to respond to to prove jurisdiction on the motion to moot. And it was really weird. I think they were waiting to see if we would wait for them. So we would be out of time responding to their weak response without an affidavit to the jurisdiction challenge with an affidavit. But that's not what we did. So just like I'm telling you guys, we don't wait. We don't wait for them to come and smack us in the face. We go smack them. So when they filed their weak response and they didn't reply to the motion to moot, well, they actually asked for additional time. We went ahead and defaulted them. And then we moved for summary judgment. And they never did file anything to respond to the motion to moot. So that's very powerful. You just have to make sure you keep the judge out of your face, because the judge ain't got no business helping them. And we learn how to cut to the chase up in here. If the judge helped them, then you know what we need to do. And we got the document in the next package I put together. The next package we'll talk about in the next couple of days for going after the judge specifically for violating your rights by taking jurisdiction without legal authority. So the third document is the notice of default, or you can make it a motion for default. Some people get stuck in the notice. Some people don't need it. I don't. A notice of default to me is the same as a default. Okay, I'm not going to get stuck in all of their rules and stuff. The notice of default is the same as I'm letting them know that they're in default. So you can run it however you want to. If you're going to get stuck in following all of the rules that they have, you probably should not be in my program. Okay, because I don't follow all of those rules, and you'll drive yourself crazy trying to, and then you'll drive me crazy with phone calls trying to convince me that you need to do that. And I'm going to be saying, I don't want to talk to you no more. Go sit on the bench. Yeah, I can go sit on the bench. I don't have the whistle to blow, but I can get one. Okay, let's move forward. So your reply, the fourth document is your reply to their weak response. And I just put this together. I had them reply without an affidavit and without addressing anything or whatever. So I put together this little response to jam them up and put you back, back in the driver's seat. And we've only had a few attorneys respond. And obviously they didn't respond. They can't respond to this by counter affidavit, and they didn't. So they failed to respond by counter affidavit. So it's a non-response, and that's the way I roll with that. And the fifth document is for summary judgment, and you're jamming them up for summary judgment because of everything that And the sixth document is a motion for hearing on your summary judgment. Yeah. Now, this is not a lawsuit package or nothing like that, but you can take the information in this and inject it into your lawsuit after you get control. This is the quickest way to get control because this attacks the jurisdiction in the eviction court or in the judicial foreclosure or whatever they're trying to do in that court. The process of filing your lawsuit in federal court is great, but if you're standing close to the edge of the cliff in federal court, they sometimes will put your shit in a basket and leave it sit over there while they hurry up and try to kick you off the property. So you want to make sure that you are aware of that situation. So the documents can be used to stop the foreclosure eviction of a non-judicial foreclosure very easily. Now, if you invested in the non-judicial foreclosure, wrongful foreclosure lawsuit packages for non-judicial foreclosures, you have all the documents you need to take control of the eviction court immediate possession issue and removing it over to federal court to be connected to your title dispute. Okay, you have all the documents to do that. If you're new to this or you're just finding us and you are about to get jammed up in the moratorium, because I know the reason I put this together is to help those people. A lot of people are going to get caught in this moratorium crap because when they did the moratorium, they kind of made it like everything's going to come to a stop. Well, that's not what happened. What happened was they're not allowed to throw you out of your house, but the court process continued. And there's a lot of folks who thought that that court process was also stopped, and it's not. So if you got documents that was served to you or whatever, and you didn't respond, then you're in default. I have two people. One lady lives in Alaska, bless her heart, and she found us while she was about to get evicted. She got her paperwork filed, but she still got evicted because I think she filed the paperwork like 2 days before or 1 day before the eviction process, or maybe on the same day, I'm not sure. But the thing is, what they did to her is they served her Friday evening after the court was closed that she had an eviction hearing Monday morning. And they did it on the computer or Zoom or whatever. So she had no idea. She was not even ready. And yeah, so they slammed the hammer down, and I don't know how many days they gave her, but she got evicted. And she still has her stuff, so she's fighting it. And I told her, you can fight or you can give up. It's up to you. But so she's still fighting. But a lot of people are going to be facing that because they thought that with the moratorium, I can chill right now. I don't have to worry about this so much. Well, you still do, because I have people that have contacted me to defend their property that work in the courthouse and that work in the title office. And all four of them told me that the attorneys never took a break and stayed home. Every day they were there doing stuff in court and in title. And you know what they were doing? They were getting ready to jam up people that are already in eviction court, and they're getting ready to jam up people for the property tax. Yep, they're getting ready to jam up people for a property tax. And yeah, I have eliminated property tax lawsuit package. That's the bomb. So if you're facing that, don't worry. You need to get the bomb. So you want to get that jurisdictional challenge with an affidavit. and put it together. Don't worry about the notice. Don't worry about the Attorney General's name. Just replace the red font and do it the way the instructions call for. The reason I have the Attorney General names on there is because the Attorney General is going to be the one on the jurisdictional challenge and affidavit is you got to serve a copy to the Attorney General. The Attorney General is going to be the one that's going to have to take care of your lawsuit when you file it against the judge for violating your rights by taking jurisdiction without judicial authority. So the goal is to get the Attorney General involved at the gate from the beginning. Remember, we're cutting to the chase. So we're figuring these things out. And I don't know how much of a difference it makes, but we're trying it. We are trying different things to help us cut to the chase and make these fools sit the hell down and leave you alone. So that's what we're working on. We're not trying to win in court, okay? Because the only way that you're going to win in court is to have the judge give you some shit. And I've been doing this a minute and a half, and I've not seen that happen. So we ain't trying to win. We're trying to make them give up and go sit the hell down. Cost them money and time. Time and money. And you stop and think about it, they have so many people give up, they hardly have time to deal with your ass screaming and kicking and scratching. Yeah. That's how we do it. We're learning how to cut to the chase. So here's the deal. If the judge is going to help them, if the judge is going to help the attorney steal your house, we need to have the strategy in place to attack the judge before they give your property away to their buddies. That's what we're working on here. The jurisdictional challenge is posted on the website at half price for $200. The document package has blocked foreclosure sales and vacated judgments for several team members in our private Facebook group. Shamel Maxwell, she's the front runner for that. I think she's like the first one to get it filed. She actually stopped her dad's, the sale of her dad's house. She vacated the judgment. Then she had to stop the sale 4 more times because they kept trying to, yeah. So, and this is why it's so important to get copies of your docket sheet on a regular basis to keep track, especially if you're getting close to them selling your house. Because what they do is they file their shady stuff and then go ahead and do the thing. And then by the time you figure out what's done, they already done the thing. And yeah, it's a little bit harder to unwrap. But if you can catch them trying to do the thing and you stick it up in their face, and then you add the person who signed to do the thing to your lawsuit, yep, now the thing turns out to be a bigger thing and they got a problem with the thing. Okay. I'm getting carried away again. So this is the best foreclosure defense value that you're ever going to find. And the best part about this is you're learning how to do it yourself. You ain't got no attorney up in your face, okay? You ain't got me up in your face. Unless you call me with questions that you already have the answers to, or you call me and ask me questions about what you have in your package. Those are kind of questions that make the coach grumpy because, like I said, I don't have time to make it easy for you. I have my hands full doing what I'm doing. So you guys got to take care of that part. So I structured the lawsuit package, the claim against the judge for ruling without jurisdiction. And that's also on sale for half price. And we'll talk about that in the next video. So I'm going to open up my share window and just kind of show you guys. Maybe. Okay, so. This is the jurisdictional challenge with an affidavit. And one of the things, I'm not going to show you the whole doc. We're just going to look at the front of it so you can kind of see. You want to, oops, no, you guys can't see it yet. I'm in the wrong window. Okay, there we go. There. Is that better? Okay, I'm learning still too. So there are two numbers here, and this was messing with people's heads. Don't worry about it. If you have a case number, use the case number. If you have a file number, use the file number. Most of you don't have a file number. If you don't have a file number, leave all zeros there. Okay, that's what I would do. Leave all zeros here. This file number represents the file that they have for your property in their administrative court. And this is my opinion based off of my research. They have a file for your house. And non-judicial, they tell you, oh, we don't have no bullshit. They have a file for your to sell your house and all that. And if they don't have a file for it, then it's something really wrong. Well, something really wrong anyway, but they got a file for it. And just having that there with all zeros in it, lets them know that they have a file. And if the clerk asks you to erase it, I would tell them, nope, you're not going to do that. And if she does, that you're going to hold her liable for obstruction of correspondence, 18 U.S.C. 1602. I can't believe I can remember that. Yeah, obstruction of correspondence. And I think it carries like a 1-year penalty and $10,000 fine. That's how you make clerks straighten up. And you can see here, all you have to do is replace the red font with information from your situation. So if you live in California, then you would put the California Attorney General's office up here and whatever. Okay, it's that simple. Now, here's something I want to show you guys. And John Castro, I want to show you this too. Even if you file your wrongful foreclosure or even if you file your jurisdictional challenge and you change it or take the affidavit off, or they just throw it out and you don't get a chance and you don't figure it out until you can file it again. Okay? Because see right here, the Supreme Court of the United States has ruled jurisdiction can be challenged at any time, even as much as 15 years after the judgment has been entered. So that bullshit that they tell you guys, the case is closed. Well, it is if you go sit your happy ass down. Well, sad happy ass down, then it's closed. It ain't closed if you don't go sit down. Now, I realize that is a little bit more of a challenge now to make them do the right shit when you have to send your stuff in the mail and you can't just go in there and start having a freaking hissy fit. Well, you can't do that if you're a big black guy either. But if you was a little black guy, okay, never mind. So don't buy that. Don't buy that crap. What you need to understand, you need to be in a different mindset. And that mindset you need to be in is this. Anytime a bar member or officer of the court or any like that open their mouth, you need to first think they're lying. Because they usually are. So they're lying. That's how you do that. You can't believe a word they say. And they're going to tell you, funny how it is. You go in there and you ask them, hey, I don't understand. How can, we can't give you no legal advice. No, we can't do that. Okay, hey, but when you show up with your document and you got the attorney listed as the number one defendant on there and the attorney's law firm at a second, no, you can't do that. You got to change this. I got people telling me, they trying to, no, we're not changing that. And usually I have you attach a file stamp copy of the a document, which is the lawsuit they filed against you, their file stamp copy of the lawsuit they filed against you. You attach to your lawsuit to show who signed it. And you attach it as an exhibit. So when the clerk starts telling you that shit, you just whip up, no. Look, let me show you right here. Flip it up a few more pages. Oh, right there. See, right there. The attorney is the only one who signed it. The attorney is the one that's initiating the foreclosure against my property, not the lender. See, look, flip it up some more. The lender didn't sign here nowhere. Only the attorney signed it. So that's who I'm suing. Only the attorney and the law firm and the third party And we're also going to sue the last servicer because the servicer claimed it as a loss on their insurance, wrote it off their taxes. Okay, then they turned around and they sold this alleged debt to third-party debt collectors for pennies on the dollar. And anybody that understands the accounting, the GAAP accounting principles would know that once you've done a charge off and claimed it off your books, it's settled. You have no entry spaces to put any additional income that you're making illegally on the side. Yep. I don't even want to get me started on all that. Let me stay focused. So this is the first one. Now, let's take a look at the next document here. Yeah, I like this one. The motion to moot all the attorney's pleadings until they prove your subject matter jurisdiction on the court record. Yeah, they're having a really hard time with this. And those of you who know me, you know I love my job. And they think they're so smart. So let's take a look at now. Make sure I get these in the right order. So the third one is going to be that motion for default. And this has been newly added. And I have another motion that I'm thinking about adding, but I need to do a little more research. So if you have purchased if you've invested in the jurisdictional challenge with an affidavit and you need this demand for default, send me an email and just tell me, hey, I invested in the jurisdictional challenge with an affidavit. You have to use the whole name, okay? Because I have several jurisdictional challenges, several challenges of the jurisdiction, and you have to use the whole name so that I understand which one you want. So I understand what you need or what you're referring to, and just let me know you need the demand for default, and I'll attach to email and send it back to you. That's the easiest way to do it, because then I don't have to worry about trying to figure out what your email is and looking it up and then sending it to somebody else. No, I've never done that. That's my story. So you'll see this notice of default. And in this notice of default, we mentioned the 6 things that are missing from the original contract that the attorneys filed in court. The original contract has 6 things that are missing from what the attorneys filed in court. And those 6 things are powerful. And if you understand them, you will be driver of the bus. I ain't playing. You will. You will be driver of the bus if you understand them. If you understand them, when they call you, when the attorney contacts you, that's all you'll be talking about. Hey, dude, I need those 6 things. These 6 things that are listed in the document that are stuck up in your face. I need copies of those 6 things that you don't have. So you need to go get them. Oh, wait, you can't. Yeah. And I have people call the attorneys and harass them. I call them suckers every other day. You know, after the first day, the gatekeeper's not gonna let you through, but it don't matter, because they'll send you to their voicemail, and then you can have your script already written out with, 2, 3, or 4 minutes of ranting about what you want or what you're gonna do or whatever, and you're asking for the 6 things. You're asking them to show you the statute that the valid law that they're using to provide the court with jurisdiction, because the statute that they use for foreclosure does not have the 3 elements to be considered a valid law, because it's missing the enacting clause, the title, and the body. Each state constitution member, we talked about that in a different video. Those are the things you want to call the attorney. People don't realize the judge is not the one to run the show in court. Okay, judge not. Anybody thinks the judge is the one to run the show, better go home and pack your shit. I'm just telling you, okay? The attorneys are the ones that run the show, and they have the program already worked out before you show up. When they don't schedule a hearing until they're ready to make an attack on you. And then they already have a plan of what they're going to do when you show up. And some people, I say this and they go, oh, yeah, it starts to make sense now. And you start to play it back in your head, and the whole time the judge and attorney were working together. That's the way it goes. So this notice of default you want to have in their face the day they are in default. I already told you they're not going to be able to respond to your jurisdictional challenge with an affidavit, and you can't be waiting for the judge, okay? Because if you wait for the judge, you're going to be on the bench. You're going to be in the locker room. You can't wait for the judge. It's the day that they're done, that they're in default. This should already be filled out. Oh, wait, let me move down here so you can see it. Okay. Here's the demand for a default. Now, you want to have this filled out and stuck in their face the day they're in default. Don't be playing around. Okay, you want to make them think this is your life. Like mine. Okay, anyway, you do. You want them to know that you ain't playing. That's what it's about. I'm just thinking. I don't have a sanction motion in here. I need to add the sanction motion to this. Oh, I gotta make a sticky note or it's not gonna get done. Yeah, the sanction motion. That's what I need to put in here. Okay. So, like I said, this document can be used to stop eviction proceedings for non-judicial foreclosures. You can use it to attack a judicial foreclosure and blow the whole case up and give yourself time to get your foot in the door in federal court with your wrongful foreclosure / breach of contract lawsuit, or your claim against the judge for allowing the attorneys to go through when the judge didn't have jurisdiction to rule and help them. So we'll learn how to cut to the chase up in here. So the judge, if the judge is going to help them steal your property, we need to have a strategy in place to attack the judge before they give your house away to their buddies. And that's what we're trying to do. This jurisdictional challenge is posted on the website at half price for $200. The document package has blocked foreclosure sales and vacated judgments for several team members in our Facebook group. And I have several property owners who are using it as well. And I have several property owners who invested in my first foreclosure defense DIY lawsuit online course. And the online course has everything that they need to protect. Everything that I offer pretty much is in that online course. And I just updated the course like last month with 7 new lectures. And one of the lectures was about how to properly state a claim. So if you invest in the package, that would be where you should start, because you're going to have to make some adjustments to the lawsuit package. And you're going to have to follow the how to state a claim guidelines to make sure that you're stating a claim according to the way the attorneys like you to do it. Now, that hasn't been a problem for us for the most part, because the information that we put in there, they can't mess with it. But I have had a couple of people that got turned away in court. They tried to turn them away in court because they didn't properly state a claim for release, which is like a real small, yeah. So I spent some time and I learned how to do that. And in the online course, I actually structured a claim. I stated a claim. I structured a statement, claim. So anybody that joins, that enrolls in the course, if they're almost about to get pushed off the edge of the cliff, they have what they need to just go ahead and paste it in and go. They also have the guideline that you can use to follow the guideline to state your own claim based off of your situation. So the video is posted on my website, and it's in how to state a claim for relief. If you just search that in the search bar and the search box at the top, I think you can pull up, there's like maybe 2 or 3 videos on that. So I structured this lawsuit package, the claim against the judge, specifically for the judge ruling without jurisdiction, and we'll go over that lawsuit package in the next live stream, and I'll tell you guys a little bit about it. So these 2 packages kind of go together. Now, you may not need the second one. You know, who knows? If you do this right, you may not need either one of them. I mean, they may let you pass. I don't know. But if they don't, then if the judge is going to help them, then we need to have a program set up for it, because that's what we do here. We make the program work for the people. So, and we make it cheap to help folks kick attorneys' asses. That's why it's only $200. So if you're looking at the price of $200 and think that it ain't the fire, then you probably should move on, get out of the way, because somebody's going to step on your back trying to get into that $200 spot to get this document to help get control of their foreclosure. I make it cheap because, like I said, this is not a flash sale. This is a kick attorney ass sale. That's what this is about. So I'm going to leave a link to both of, wait, I think I have one more document here. Let me check. I think I got one more document to show you guys. No, we got 2 more. So we have the motion for summary judgment. And you'll have to put your, if people have trouble looking up the statutes, if they want to put statutes in from their state or whatever, all you got to do is look at summary judgment for your state, and they'll pull up the statute. Or if you're looking for the property title statute for your state, that's how you do it. It's easy. Just go to Google and put it in, pull it up. I had one team member tell me, "Oh, I never used Google because I didn't think it was going to be like, oh my God." And then we wonder why we're struggling so bad. Google it. You don't have to go to the law library and do all of that crap, okay? Remember, that crap is what they put together for you to bring to the table, okay? I don't worry about a bunch of case law. At the end of the day, now, I'm not saying I don't have case law on my shit, but here's the deal. At the end of the day, the facts are more important than the case law, okay? Because if you can't get past the facts, we ain't even got to worry about the case law. That's the way I roll. So, and I see it a little bit different. So I'm going to have a link to both of those documents posted for the people that get stuck in this moratorium rush when the gates open up. And, I have it priced at $200. That's the best I can do on that. To help you guys get in the door. And please leave me leave me a Google review on the document. I'm asking people to review the document and decide if you think the document has value for your situation. And if you think it does, that's what you should be talking about in the review. And let people know that you're going to do a follow-up, to talk about the progress. Okay, because I need people to see that my shit is fire and what I'm doing is real and I ain't playing. And if nobody leaves me a Google review and they don't specifically mention the jurisdictional challenge with an affidavit or the specific document they got, then people reading it and have no idea if the document that they need is the one that's going to help them, because they don't know what document you're talking about, or because no one took the time to leave a review because they didn't think it was important. And those same people are the ones that's calling me all the time. Okay, I'm not naming any names. Okay, guys, just leave me a review. Okay, we can make it easy if we want to. We make it complicated. I like to have it easy, but it needs to be done. So this helps other people see that there's value in this program. So one more document, and then we're going to move forward. And let me get some of these out of the way. Okay, the last document was the motion for a hearing, but I think I closed it up, so I'm not going to worry about it. Let me go ahead and stop the share. Get back in the main office. So, and let me open up here and see what kind of questions we got. So, well, Ali, if they still try to serve, so what you need to do is what I would do if you have time is serve them file stamp copies of the title dispute or your challenge or whatever it is that you're sticking in their face. And once you have verification that you've served them, if they move forward, you can add their asses to the lawsuit. So we ain't even trying to play. And this is one of the reasons why I don't like to add a whole bunch of people in the beginning, because all of those people in the beginning, don't have nothing to do with what's going on right now. And if you add all those people, then it makes it very complicated. And then when the end, if you got to add the clerk's ass on there because they're not doing their job and filing the stuff, or like in Shamel's case, they picked up her stuff at the post office and then tried to say it was lost for 2 or 3 days while they went ahead and sold her dad's property. And no, she found out right away who signed because she had the thing. She sent it and she made them sign for it. So she already knew who picked it up. And the next day, she was right back over there in the office with an amendment, adding that clerk who signed to pick it up to the lawsuit. And the reason she did that is because that clerk who picked it up should have put her stuff on the record dated the same day freaking picked it up. Yeah, and when she started doing that shit, they started straightening their ass up. She said the head clerk told her one day that her legal team made some powerful documents or something to that effect. But I know that there's a lot of people that are watching the videos and are putting their strategies together. I got a call today from a lady from Texas, and it was a very refreshing call. And she started talking and telling me about she'd been fighting her for like 11 or 12 years, and that she figured out that you needed a title dispute to block the eviction court process. And I was like, what? Because she's the only person that's called me and talked about that. I was really impressed. And so I told her if she needs anything, she needs to let me know. And she got them wrapped up pretty tight. And that comes from a lot of studying. So those of you who think that you're not going to have to, change your life to make this work are going to be in for a surprise. So, because you got to change stuff and spend some time. So that's all I got tonight, guys. I will see you guys next week. And make sure if you need that jurisdictional challenge with an affidavit that you grab it and stick it up in their face, because it's going to make one world of a difference. Now let me figure out how to turn this off.